So, this big UK constitutional case concerning the suspension of Parliament reaches the UK Supreme Court. And what do they decide? Hello everyone, this video follows on from the previous video concerning the attempt by the UK government to suspend Parliament for 5 weeks in the lead up to withdrawal from the European Union. The case has now reached the Supreme Court, and the question before the Supreme Court justices is whether the Prime Minister's advice to the Queen to prorogue Parliament, suspend Parliament for a period of 5 weeks in the autumn of 2019, whether that prorogation was unlawful. The Supreme Court, in an extraordinary judgment, decided yes, the advice given to the Queen by the Prime Minister was indeed unlawful. All 11 justices of the Supreme Court agreed with this position, which was delivered in a single speech by Lady Hale, the President of the Supreme Court at the time. So it was an extraordinary judgment and an extremely powerful statement by the Supreme Court, as well as a deeply embarrassing loss for the government. This judgment by the UK Supreme Court will be read, digested, reflected on, pondered by constitutional lawyers in the UK and in jurisdictions across the world for decades, maybe centuries to come. What we need to do is unpack the Supreme Court's judgments. The first issue, the first obstacle facing the Supreme Court was this issue that was facing the English High Court and that we talked about in the previous video. The question here is this matter justiciable? Are there legal standards that are applicable to this matter and that the courts can therefore turn to and employ to evaluate what the government has done? The Supreme Court drew an important distinction here. It said, first of all, there is a question about whether a prerogative power exists, and if so, what its extent is, what the limits of that prerogative power are. Those issues are absolutely justiciable. Those issues do fall within the purview of the courts. There are legal standards that are applicable here that can determine this. The Supreme Court noted that a second sort of issue might also arise where it's accepted that a prerogative power exists and it's accepted that the power has been exercised within its legal limits. The question there might be whether the exercise of the power could be open to legal challenge on some other basis. And on that matter, the court reserved judgment. It said that, well, that may depend on the circumstances and you would have to look at the particular case in question. Importantly, the Supreme Court viewed the facts of this case as falling under the first category. The facts of this case, the Supreme Court thought, go to the question of the legal limits of the power, the prerogative power of prorogation. A starting point here for the court is that the government can't do whatever it likes. It can't decide to lock you up just because it feels like it. It has to act on the basis of powers that it has been granted under the Constitution. Now, the source of these powers might vary. Sometimes these powers might be found in legislation, in Acts of Parliament, for instance. In other cases, the powers might be, for example, prerogative powers, as in this case. Whatever the case may be, those powers have limits. There are legal limits to the powers that have been conferred. And that is also the case, the Supreme Court said, in relation to the power of prorogation. That prerogative power equally has legal limits in just the same way as any other power that's conferred upon the government. It is not the case that the government has unfettered, unlimited power to do whatever it likes. What follows is that the courts are indeed capable of monitoring whether the government is acting within the legal limits of a particular power, or indeed whether its action has gone outside those limits and therefore needs to be struck down. All of this is critically important because the court viewed the facts of this case through this lens. It regarded the issues, the prorogation issues in this case, as being about whether the government's action fell within the legal limits of the power of prorogation or whether it fell outside those limits. And so the question that the court thought it was addressing was whether the Prime Minister, in deciding to advise the Queen to suspend Parliament for 5 weeks, whether that decision would be falling outside the legal limits of the power of prorogation. And if so, that's something then the courts could look at, could monitor, and could address. And in assessing all of that, well, this is justiciable. This is absolutely something for the courts to monitor. They have to be able to monitor the legal limits of governmental powers to ensure that government is acting in accordance with the law, in accordance with the powers that have been granted to it. The Supreme Court therefore took the view that the question before it concerning the prorogation issue that had arisen in the autumn, this question was justiciable, and there it disagreed with the High Court, who had thought that the issue was not justiciable and had therefore dismissed the case. The Supreme Court disagreed, and once it got over that obstacle, then it proceeded to examine the next steps of the matter. Given that the question is justiciable according to the Supreme Court, so in other words, there are legal standards that are applicable to this matter, given all of this, what are those legal standards? That's what the Supreme Court looked at next. And it said that there were two fundamental constitutional principles that were relevant here. The first was the principle of parliamentary sovereignty, and then the second was the principle of parliamentary accountability, or in other words, ministerial accountability to Parliament. This first principle, parliamentary sovereignty, so this idea that Parliament has ultimate legislative authority within the UK Constitution, the Supreme Court thought that that principle would be put in jeopardy if essentially the government could suspend Parliament whenever it wanted, for whatever reason it wanted, and therefore prevent Parliament from being able to exercise its legislative authority, from being able to legislate. And if there were no legal limit on the power to prorogue Parliament, then the government, through the Queen, could prorogue Parliament, suspend Parliament for as long as it liked. It might mean in the most extreme situations that Parliament could simply be suspended from one general election to essentially the next one. That couldn't be right, the Supreme Court thought. In other words, the Supreme Court was taking the view here that the principle of parliamentary sovereignty, this fundamental constitutional principle, furnished some sort of legal limit on the power of prorogation. The second constitutional principle that the Supreme Court drew attention to was the principle of parliamentary accountability. In other words, ministerial accountability to Parliament. The court said that this lay at the heart of Westminster democracy. And the problem is that when Parliament is prorogued, when it's suspended, the capacity for Parliament, for the House of Commons, the House of Lords, to scrutinise and hold to account government ministers disappears because Parliament is shut down. And the Supreme Court's view was that it's an essential tenet of Westminster-style democracy that the government, that ministers are accountable to Parliament, that they have to explain themselves to Parliament, that they are scrutinised by Parliament and so on. This is central to the parliamentary Westminster-style democratic system that we have. In other words, if the government can simply prorogue Parliament whenever it wishes, for as long as it wishes, conceivably in the most extreme situations from one election to the next, then that would also demolish the principle, this fundamental constitutional principle of ministerial accountability to Parliament. And so again, the court was not persuaded by that and thought that this second fundamental principle also helped furnish legal limits on the power of prorogation. Through this analysis of these two fundamental constitutional principles, the court elaborated on what it regarded as key aspects of the legal limits to the power of prorogation. And on the basis of all of this analysis, the court then put forward a test, a legal test, which encapsulated and which set out the precise legal limit of the power of prorogation for the purposes of this case. And it was an effect-based test, and the test goes like this. The court says that for the purposes of the present case, the relevant limit, the relevant legal limit upon the power to prorogue can be expressed as follows. A decision to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature. In other words, here we're referring to the principle of parliamentary sovereignty, and as the body responsible for the supervision of the executive. Here we're referring to the principle of parliamentary accountability, ministerial accountability to Parliament. So you can see how those two principles are furnishing the core elements of this legal test that the Supreme Court has advanced. This is the legal test that encapsulates, for the purposes of this case, the relevant legal limits on the power of prorogation. The court then applies this test to the facts and finds that the Prime Minister's decision to advised the Queen to prorogue Parliament was indeed unlawful. Given the length of the proposed suspension, 5 weeks, and the timing of it, so 5 weeks at such a critical time in the lead up to the imminent UK withdrawal from the European Union, all this meant that the Prime Minister's decision to suspend Parliament in this way and at this time had a sufficiently serious effect on Parliament's constitutional functions. And the Supreme Court was very hard-hitting with this. The Prime Minister's decision had an extreme effect on the fundamentals of our democracy. The legal test that the Supreme Court articulated did provide an escape route for the government. So a government might well, in certain circumstances, propose a 5-week prorogation or perhaps even longer. And the escape route is that it should be able to supply a reasonable justification for this. The court's review here would be light touch, it said. However, what it found was the government in the proceedings before the Supreme Court offered not only no reasonable justification, but no justification at all for the proposed prorogation. And so on that basis, the court had no choice but to conclude that this proposed 5-week prorogation at this critical time was indeed unlawful, according to the legal test that it articulated. Lastly, when it came to the outcome, the court took the view that Parliament had never been prorogued. So that was the Supreme Court's judgment, an absolutely extraordinary decision, and one that will echo for decades, centuries to come. The government's nose was very heavily bloodied in this, and they were very unhappy at the outcome. They disagreed with the outcome, and more recently, the government is now proposing to find ways in which it might limit circumscribe the reach of judges. So we'll have to wait and see what the outcome of all of that will be. The idea that there are tensions between the government and the courts is not a new one. But there are heightened tensions at the moment. One question that I'll be asking my students is whether they agree with the Supreme Court judgment in this case, and more generally zooming out, what they think about the relationship between the courts and the executive. Do they think that judges are perhaps sometimes going too far in intervening in some of these cases? Or do they think, for instance, that the courts are striking the right note and are doing strong and important work in holding the executive legally to account and making sure that they obey the law? So these are all big questions, important questions, ongoing questions for any constitution, for any legal system. I'll stop there. Thank you very much for watching and take care.